All right. Court of Appeal in the Court of the 5th District of the State of Florida is now in session. The Honorable William D. Palmer, Judge, presiding. All persons having business before the court draw near, give attention, and be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning and welcome to an oral argument session of the 5th District Court of Appeal. Let me begin by introducing the panel. As you've already heard, I'm Judge Palmer. To my right is Judge Sawaya. To my left is Judge Edwards. We have 2 cases on the docket today. All the others have been continued or dismissed. They're both civil cases. Each side will have 20 minutes. The appellant can reserve as much time for rebuttal as they like. If you've got any cell phones, please make sure they're turned off so they don't interrupt us during proceedings. The first case is Bishop versus R.J. Reynolds.
Good morning. May it please the Court. George Vaca with Vaca Law Group on behalf of Ms. Bishop as personal representative of the estate of Robert Ramsey. At the outset, with the Court's indulgence, I'd like to reserve 5 minutes for rebuttal, please.
All right. When the yellow light comes on, you will be into your rebuttal time.
Thank you, sir. We're here today asking this Court to reverse a final judgment entered in favor of the defendant tobacco companies with directions on remand for the Court to conduct a new trial. Briefly, as the briefs point out, this was an Engel progeny trial. We were required to prove as the first element of that case that Mr. Ramsey was a member of the class. In order to do that, we had to demonstrate that he was addicted to cigarettes containing nicotine, and such addiction was a legal cause of his, in this case, lung cancer, the qualifying disease. To meet that burden, Ms. Bishop offered evidence of Mr. Ramsey's smoking history, his smoking-related illness, expert testimony regarding addiction to nicotine and the cause of his lung cancer and death, and also offered lay witness testimony regarding his addiction to nicotine, which we believe was erroneously excluded. The evidence of his smoking history is presented at page 4 through 6 of our initial brief.
You think that it's permissible to allow lay testimony as to the specific issue as to whether he was addicted?
Yes, Your Honor.
Right. What's the difference between saying you're addicted and saying that you're hooked? Is there a big difference?
I think in the vernacular to most lay people, I think it's important, an important distinction.
A family friend testified that he said that he was hooked and couldn't stop. I mean, what's the difference between that and the phraseology, well, he's addicted? Isn't that basically the same thing?
Well, I think there's two things that come up here. There's the testimony of the friends and the family members as to their observation that they believed he was addicted. And then there's the separate statement made multiple times by Mr. Ramsey to various family members. In particular, the one that we cited in our brief was to his daughter, when asked why he continued to smoke, and he said he believed he was addicted. Now, the jury in this case, after having heard the testimony from all of the friends and the family members, and where they heard he was hooked, asked the specific question, did Mr. Ramsey ever say that he was addicted? So to the jury...
But a family friend was allowed to testify that he said that he was hooked, and then they admitted all this other testimony about the fact that when he got up in the morning, he had a cigarette, smoked throughout the day, smoked before he went to bed, and did this for a number of years. And so let's assume that I say that I'm of the opinion that it was error to exclude opinion testimony as to the issue of addiction. Would it not be harmless since the jury heard all of that evidence and testimony?
Well, I certainly don't believe that the defendants can satisfy their burden under special to show that there was no possibility whatsoever that this affected the jury's consideration of the case. In fact, in light of the question, I would think it would be impossible for them to meet that burden. So the question is not whether it was harmless or not. The question is whether or not there was a reasonable possibility that the exclusion of that evidence affected how the jury looked at this case.
Do you have a case that specifically says, I mean, goes right to the heart of the issue and specifically says that lay opinion testimony is appropriate concerning the issue of addiction?
Yes.
I know we've got some cases where, you know, the courts looked at it and said, well, the evidence was sufficient, the expert testimony and the lay testimony. But have you got a case that specifically says that?
The Brown case, that was the issue that R.J. Reynolds raised on appeal, that it was an error to admit that evidence in trial for the purpose of addiction. And the 4th District wrote a decision that said, we reject that. The evidence was properly admitted. In this case, it should have been properly admitted. We argued those cases to Judge Egan.
Well, the key issue each way would, the actual characterization of the issue is whether or not it was an abuse of discretion, right? Mm-hmm. Not whether the evidence should properly have come in. In one case, it could be not an abuse of discretion for a judge to let it in. It might also not be an abuse of discretion for the judge to keep it out. Would you agree with that?
Here's where I would try to draw that line. The only reported appellate decisions involving nicotine addiction are cases in which the courts have said it was not an abuse of discretion to allow it to come into evidence.
But that doesn't establish authority to say it would be an abuse of discretion not to let it in. Would you agree with that principle?
I don't know that it necessarily stands for the exact proposition Your Honor's citing it for, but it certainly is, at a minimum, persuasive authority that the evidence was both relevant and otherwise admissible and should have come in, and we were deprived of that opportunity. Also, if you go to the Alexander case, okay, Mr. Ramsey's own explanations as to why he continued to smoke, even knowing the harm, and his belief that because of addiction, clearly goes, the objections that they were raising to this was, A, it's hearsay, B, it has to be a specialty diagnosis by somebody who's an expert, okay? And clearly his out-of-court statements demonstrating his state of mind as to why he continued to smoke is admissible evidence. And the judge kept that.
Is his state of mind relevant?
Absolutely.
If the issue is whether he or not he is addicted, is his state of mind whether he thinks he's addicted or not controlling? Relevant?
I think it's admissible, relevant evidence to explain why, in accordance with the Fagerstrom test that Dr. Hurt testified about, why somebody would continue behavior that they know to be harmful and nevertheless continue to smoke. That was one of the indicia that the expert relied upon.
If you had a plaintiff, not a decedent, but a plaintiff who had been injured and was suing, and the plaintiff took the stand, A, could he testify, I was addicted, and B, would that be enough to go to a jury? Is that all you need to get to a jury, is the plaintiff to get on the stand and say, I was addicted?
I believe that that's exactly what happened in Grossman, which is another case where this testimony was admitted into evidence, where Mr. Grossman and Mrs. Grossman testified about their beliefs that they were addicted, that the wife was addicted. And so, yes, I do think, if you look at Grossman, you look at Brown, you look at Alexander, and you look at Mrozek, those 4 cases all talk about this very issue. And all of those cases, Brown specifically, they said it was error to admit it, and the 4th District said absolutely not. And it's relevant, and it's otherwise admissible evidence. And once we demonstrate that, then I think it's their burden under special to show that it could not have reasonably, possibly affected the verdict. And in light of the jury question on this issue, I don't see how they could ever do that. Now, they've raised the 2-issue rule in response to that, and as we've pointed out in our brief, and I think this Court's decision in Marriott, the Supreme Court's subsequent decisions clearly make undeniable that this 2-issue rule doesn't have any application in this case. We're not talking about various theories of recovery. We're talking about one, which is class membership. This is an element, causation is an element of class membership. They say, well, they could have went off on this possibility that Dr. Villa talked about, that Mr. Ramsey had a skin cancer, and it was possible that that was the primary cause of cancer. The defendant's defense in this case, other than cross-examination, they didn't put on any witnesses. They put on a 5-minute video clip of Ms. Bishop's deposition. That was it. They didn't put on any expert testimony. They didn't bring in anybody, any pathologist, oncologist, anybody, to say that Mr. Ramsey didn't die from lung cancer.
How many expert witnesses did you present concerning the issue of addiction?
One.
Right, and that expert was allowed to testify, these are the facts, and this is based on these facts and circumstances that I conclude that he was addicted?
Yes, that was...
And then you've also got the family friend that said that the decedent specifically said he was hooked and couldn't stop. And you've got the family members testifying about the fact that, you know, his smoking habits and how often he smoked and for how long. You don't think that there would be a logical argument that could be made that the trial judge, in considering all that, did not abuse his discretion in saying, well, that's enough, we don't need the lay opinion to finally say that he was addicted when we got the expert and all this other testimony?
I think what the judge got from the lay witnesses was their observations, some of their observations. I don't think there's any question about that, Judge Sawaya.
But I think the expert said that there are certain factors or certain facts that he looks at to determine whether there's addiction, and the lay people testify.
Absolutely, and here's what makes the exclusion of the evidence so harmful in this case. If you go back to Brown, in our motion for a new trial, we provided Judge Egan with the briefs in Brown. And in Brown, Reynolds laid out its strategy for handling a case where there's no lay opinion. And the strategy was brilliantly developed and executed in this case. They kept out the lay opinion on addiction, and then what did they do with Dr. Hurt? The only person they said gave any type of opinion about addiction. They excoriated him in their closing argument on cross-examination based on financial bias. Mr. Walker got up there and he hammered him on the $5,600 to testify. He hammered him on the fact that he comes into courts throughout Florida and using the Fackerstrom test always finds that the people are addicted. He called it a rigged test.
Do you think that the issue of addiction requires an opinion, or is it can it be an issue of fact?
Well, I don't think there's any question it's an issue of fact. The Allen case that they cited says
but
that.
an issue of fact that doesn't require an expert opinion to come in and say that, in my expert opinion, I've examined, and this is my expert opinion, and my expert opinion is. In other words, there's a difference between opinion testimony and fact testimony.
Yes.
There can be. And if you're a family member and you've lived with this individual for 30 years, can that family member testify as to an issue of fact and not have to render an opinion? It's my opinion. I'm just telling you he was addicted because of all these factors.
I think the family member can do both, and I think the cases that we've cited have stood for the proposition that it would be admissible, relevant testimony if they testified that way. Do I think it's required that you have expert testimony? I think Grossman stands for the proposition it's not. So we would take the position that you're allowed to introduce both, that they are...
Well, I think the cases say there are other ways to prove addiction other than expert testimony, but that doesn't necessarily mean that lay opinion testimony is necessarily admissible either. I mean, it just says there's different ways to prove it.
Well, I think that I'm fairly...
That was my reading of the cases.
Sure. In the Ballard case out of the third, the issue again, it said the only individualized testimony on addiction came from Mr. Ballard himself, who was not qualified to offer expert testimony.
Yeah. Okay.
So, I mean, I think the cases that we've cited to the court clearly stand for the proposition that that testimony in and of itself is admissible testimony. In Ballard, it was the issue was that a DV should have been granted, and the court said no, that was sufficient evidence to withstand a DV motion. It wasn't required to have individualized expert testimony. In this case, we offered testimony that was of different kind and quality. The family member's testimony clearly was different from Dr. Hurt's, and more importantly, they were not subject to the same claims of financial bias that Dr. Hurt was. That was the strategy. If you look at the closing argument, Mr. Walker's entire closing argument, based on choice, and the only person who got up here and told you that he was addicted was Dr. Hurt. The guy, you remember him, he's the guy that charged $5,600. He must have said it a dozen times, and we cited to that in the brief, okay? That testimony of the family members was not subject to that. I mean, Mr. Ramsey's admissions that he couldn't stop smoking and he continued to smoke because he was addicted were made before there was ever an Engel case. Engel got filed in '94. He was dead. So with respect to that, and then going back to special and the standard of review, I just don't see how in light of the jury's question on this specific issue, clearly the jury was concerned about this. Clearly this was something.
Closing argument, were you able to tell the jury that in answer to your question, here's the testimony and take a look at it, and this is what the family friend said, that he said that he was hooked and couldn't quit?
We could not say that the jury specifically wanted to know from Annie Bishop that he...
In closing argument, you could say that the family member testified that the decedent said he was hooked and couldn't quit.
Well,
And you could argue that to the jury in closing argument and basically answer their question for them in that way.
and run the risk of violating the judge's ruling that we couldn't...
See how you could do, you could tell the jury, ladies and gentlemen of the jury, the family member specifically testified, and it's in the evidence, this is what the testimony reveals, that he said he was hooked and couldn't quit.
Well,
And that would answer their question. I mean, you wouldn't even have to say you asked the question, but we didn't answer it for you, but answer it that way, right? Did you do that? I mean, was that done? I'm sure it was done.
I'm certain that all the testimony was gone over. The concern was, okay, that this was a question that the jury wanted to know what Mr. Ramsey specifically said. And the judge said no. And he said no, not because he disagreed with the ruling in Alexander, which would have provided the basis, the legal basis to allow that to come in.
Yeah.
What he said was, I've got to be consistent. I made these pretrial rulings. I can't change in the middle of the trial.
Was that question during deliberation or following a witness's testimony?
It was following Mrs. Bishop's testimony. It was also following the testimony of Jennifer, the daughter, and of the friend who had testified. So at the conclusion of all that, after they heard the friend say that Mr. Ramsey thought he was hooked, they came back with this question about specifically, did Mr. Ramsey ever say he was addicted, and the jury was not allowed to get an answer to that question.
Why would lay opinion testimony be admissible for this, whether you consider addiction medical, psychological, or a combination? How is it admissible for that when it wouldn't necessarily be admissible for, did somebody suffer a permanent injury in a personal injury case?
Well, I think that's a little different question. A permanent injury is one which requires all the medicine, all the other things. The courts have said, hey, wait a minute, addiction, at least the courts who have addressed the issue, have said, no, this evidence is competent evidence within the parameters and the purview of ordinary people in order to come in and testify about their opinion, and that would go to the weight, not to its admissibility. So certainly the jury would be free if they decided to give greater weight to an expert medical opinion on this versus a lay opinion, but that doesn't provide the basis to exclude the lay opinion, at least not in our view.
You're down to about 3 minutes if you want to save it.
With respect, yes, with respect to the other issues we raised in the briefs on the exclusion of the Surgeon General's reports and the like, we'll stand on.
You believe that your strongest issue, your strongest argument is the exclusion of the lay opinion testimony?
The exclusion of the lay opinion testimony and Mr. Ramsey's admission that he did not believe that he could stop smoking because he was addicted. That's an 8033 exception, and it quite clearly is relevant evidence that we don't believe they can satisfy their burden of proof to demonstrate that there was no possibility it affected the verdict. Thank you.
We've got about 2.5 minutes left for rebuttal.
May it please the Court. Jason Burnett on behalf of the appellee, the REYNOLDS Tobacco Company. Good morning, Your Honors. Judge Sawaya, to answer your question directly, in closing argument, Ms. Bishop's trial counsel did make the argument that Mr. Crisatiello, the family friend, the supervisor of Mr. Ramsey at Texaco, said that Mr. Ramsey said of himself, "I'm hooked." That's at
They can
32.
testify that the person is hooked. If that's an opinion, why shouldn't they just be able to give the opinion he was addicted?
Because the addiction question is the ultimate issue in the case. There's,
What's the difference between being hooked and being addicted? Same thing, isn't it?
on plaintiff's own theory of this case, tobacco addiction is a specialized issue. There was not just one, there were two experts who testified in this case about addiction, Dr. Henningfield and Dr. Hurt. And those experts testified that tobacco addiction is a brain disease, that nicotine is a drug that causes physiological changes in the brain, and that the behaviors by Mr. Ramsey reflected that brain disease. That was the testimony in this case. That's the way the plaintiffs chose to frame the addiction issue. They framed it as a term of art, not as a vernacular or colloquial conception that lay people can describe. And yes, Mr. Crisatiello was allowed to testify that Mr. Ramsey said of himself, "I'm hooked," just as Ms. Bishop was allowed to testify twice that Mr. Ramsey said of himself, "I can't quit. It's too hard. I can't quit." And as well, Ms. Hardman, the daughter, was allowed to testify that my father told me he could not quit smoking. Now, to the extent there's a difference between specialized clinical medical definition of addiction, which is what the plaintiffs' experts testified.
Forget about, the standard as to whether the trial judge abused his discretion. Do you believe that lay opinion testimony should be admissible to determine if it's a close family member that's observed the individual for a long period of time, lived with them, knows their habits, to say that he was addicted?
No, Your Honor.
You don't think that's appropriate?
No, it doesn't meet the requirements of 701. And importantly, in her two briefs to this court, even in the presentation this morning, Ms. Bishop has not made any argument that the trial judge misapplied 701. Take a look at the briefs. There's no analysis of 701 in the briefing. And she has the burden to prove that the trial court abused its discretion in excluding lay opinion evidence, meaning that no reasonable judge could have reached the same conclusion. That's just not possible on a record where the plaintiff's expert testified extensively about the specialized nature of tobacco addiction, the fact that it's a brain disease. Dr. Hurt's testimony of why he opined that Mr. Ramsey was addicted was based directly on these factors. He mentioned the Fagerstrom test, the heaviness of smoking index, the diagnostic and statistical manual. He pointed to the fact that Mr. Ramsey needed to smoke first thing in the morning. And why was that important? Because of the brain disease of tobacco addiction, because he needed the dose of addiction the following morning because the nicotine had depleted from his brain the night before. You need an expert to give that kind of testimony. You need an expert to give medical causation testimony.
And why do the cases say that you don't necessarily need expert testimony to establish addiction? They can do it in other ways. Why do the cases say that?
So we have three
They
cases.
do say that, don't they?
No, Your Honor, I disagree. Let me describe our view of those cases, and I think it's clear from the face of those opinions. So you have the Brown and the Ballard decisions. Brown from the 4th DCA, Ballard from the 3rd DCA. Both of those cases are about sufficiency of the evidence. We argued that there wasn't sufficient evidence of class membership and addiction in a case where they did not put on expert testimony directly that the smoker in that case was addicted. They had generic experts who testified generically about the indicia of addiction. Then the lay witnesses came in and talked about the facts, and the jury was allowed to infer, okay, here's the expert describing the indicia, here's the lay witness describing the facts, and they combined the two. We had no problem with that. That's fine. Now, we also made the argument that the lay opinion on addiction in those cases couldn't substitute for the absence of expert opinion. But the courts didn't need to reach that question because the only question in those two decisions was whether there was sufficient evidence. And when in the Grossman, the 3rd case, that is a case where we made the argument here that lay opinion on addiction should not have been admitted. And the 4th DCA looked merely to its earlier decision in Brown, which was a sufficiency case, not this case. And importantly, none of those cases, not any one of them, strips trial courts of their discretion to admit or exclude testimony under 701.
So is it your position that Grossman is distinguishable or that Grossman is bad law and we shouldn't follow it?
Grossman does not purport to take away the discretion of the trial courts. That's the first point. I think Grossman did err in relying on Brown, which was a sufficiency determination and not an admissibility determination under 701. If you look at those opinions, there's not an analysis of 701. Ms. Bishop is asking for a complete new trial. After a 3-week trial, 5 expert witnesses, 3 fact witnesses, a new trial, without ever explaining how this ruling misapplies 701. That's the first step. She talked a lot about the harm of the supposed error, and it's harmless for the reasons that we've explained. But there hasn't been a demonstration of error in this case, of abuse of discretion. The trial court should be permitted to use their discretion. As you mentioned, Judge Shawaya, there was a lot of evidence in this case, a lot of evidence that would support the trial court's determination. One, that it's a specialized issue, so it doesn't meet 701 subsection 2. And there's also a lot of evidence in this case that the 3 fact witnesses who testified were permitted to describe Mr. Ramsey's smoking behaviors and repeatedly testified that he said of himself he couldn't quit. So to the extent there's a difference between the specialized meaning of addiction, again, which is what their plaintiff's experts describe, and the sort of lay or vernacular conception of people just using the term, well, that second aspect came into the case, but just not using the word addicted. It came in through the testimony of Mr. Crisatiello, who said, Mr. Ramsey said of himself, I'm hooked. Mr. Crisatiello also was allowed to testify that he had a problem, referring to Mr. Ramsey. He had a problem. He said he was hooked. Now,
What's the impact of the fact that defense counsel pointed out in closing argument that the only person that said he was addicted was the expert? I mean, doesn't that kind of create problems with your harmless error analysis?
No, Your Honor, I don't believe it does because, again, addiction was a specialized issue in this case. And so they had an expert, and we did not at any point suggest to the jury that the question of addiction was anything other than a specialized medical issue. We defended the question of addiction on the basis of this expert testimony. We said, yes, given the expert testimony that he had a brain disease and he was addicted to nicotine and the withdrawal symptoms that would be shown when he tried to quit during his vacations, we said, well, given all that, what about the medical episode in the 1970s when he was sedated? He didn't smoke for almost a month. The testimony of their experts would be that he wasn't suffering any withdrawal symptoms at the end of that period, but then he went back to smoking. And we characterize that as a personal choice to smoke, not the constrained choice, using the terminology of Dr. Henningfield, not the constrained choice of an addicted smoker, because he was through the withdrawal symptoms. That was our argument on addiction. We didn't come to the jury and say, ignore their experts. Addiction is a lay concept. That didn't happen. That would be opening the door. We do get to talk about addiction. It's a central issue in the case, and we get to fairly point out that the plaintiff's expert routinely testifies, routinely makes quite a bit of money from his testimony. Those are just basic bias points. And that's not true of the lay witnesses, sure, but the trial court judge has the discretion to draw a line on this very central issue of addiction on who gets to testify, and it should be a qualified person who renders an opinion on whether someone is addicted, especially when you have all this testimony in the case, 3 fact witnesses describing for many pages of the trial transcript the facts of Mr. Ramsey's smoking behavior. There's just been no demonstration of error in this case. I mean, the only 2 grounds for arguing for the admission of the lay opinion is 701, we haven't seen an analysis of 701, and door opening. And then you get to, well, was the error harmful? And it's not harmful for all the reasons that we said. There was abundant testimony in this case from 2 experts, 3 fact witnesses, to allow the jury to know that the plaintiff, from the defense point of view, that Mr. Ramsey was not addicted.
Would you address the 2-issue argument? Is this a case that fits under the 2-issue rule, or are you using some analogy to the 2-issue rule?
Judge Palmer, it's an analogy, I think. We don't have a case directly on point. It's a difficult issue, in all candor. You don't need to reach that issue if you find there was no abuse of discretion. But if you think there may be an abuse of discretion here, then I think you've got to reach the 2-issue rule. And it's a technical, difficult issue, because you've got the 2 Supreme Court precedents, Barth on the one hand and Grinitz on the other. This seems to fit the policy of the 2-issue rule. Barth says when there are separate and distinct theories of defense, we're not going to presume that any alleged error actually had an effect on the jury's verdict. And that's what Ms. Bishop is asking you to do. She's raised this issue about the question of addiction, but we had a separate defense to class membership, medical causation, and it was a substantial one. It went to the jury. The trial court denied a directed verdict. There's no way to substantiate the assertion that the jury said no to question 1 on the basis of addiction. It very well could have been that they accepted the testimony that...
Really, the 2-issue rule has to do with whether there are 2 separate avenues of recovery or liability, And you can't really determine, one would be appropriate and one wouldn't, and you can't really determine which it is according to the jury verdict because they didn't specify. But we're talking about evidentiary rulings here as to whether it was appropriate to, or whether the trial court abused its discretion in denying the lay opinion testimony, and I fail to see how the two-issue rule can apply to that. I really do.
I understand, Judge Sawaya.
I don't think that's what the two-issue rule is all about.
Well, the Barth decision says when the defense theories are separate and distinct. So think of it this way. Assume the jury agreed.
There's only one theory of recovery, either he was addicted or he wasn't. But when you talk about the evidence and testimony that's admissible to prove that one avenue of liability, I don't see where the two-issue rule. But in any event, you raised it and I can understand it.
Well, there are 4 claims in the case. The addiction is a threshold issue, right? They have to be a class member.
The addiction issue is a central issue here, isn't it?
It is.
That's the most important issue that we're talking about.
Yes. Yes, it is, Your Honor.
But it's not sufficient by itself. They
It's
have
not.
to answer the second part of the question, right?
That's correct.
Was there any request or attempt to break up that question to have a verdict form that answered them separately so we would know which of the 2 prongs the jury may have decided on?
No, Your Honor. Not by the plaintiffs, not by the defendants either, in candor, but not by the plaintiffs. It has been asked that way. It has been asked that way in numerous cases. I have a little more experience in the federal trials of these cases, and that was the norm. There would be 2 questions. Was the smoker addicted? And if they answered yes to that question, was the addiction a legal cause of the, whatever the disease would be? So it's very easy for plaintiffs to request that question. And whether they get it or not, they survive the 2-issue rule. And so here we're in a situation where we've got 4 claims, not one claim, strict liability, negligence, concealment, conspiracy, 4 claims. It's a multi-claim case. The addiction causation, class membership, that's a threshold issue before you even get to those 4 claims. And you can assume, we can just assume the jury agreed with Miss Bishop that Mr. Ramsey was addicted. Just assume that. They could still have answered no to the first question because they said, well, he had squamous cell skin cancer, 8 months before his lung cancer. Dr. Villa, their medical expert, testified that squamous cell is the most metastatic form of cancer, and the most common site of metastasis is the lung. So there was evidence from which the jury could have been persuaded, and in fact, the jury, if we're talking about jury questions, they asked Dr. Villa 7 questions after his testimony, going to issues like medical causation. So they were interested in this aspect of the case, but that's not even part of the 2-issue rule analysis. You just have to determine, well, did a separate and distinct theory go forward to the jury? And it did. It did in this case. So I recognize that the issue is not as clear-cut on the 2-issue rule, but I think it is clear-cut on the question whether there was an abuse of discretion, whether any reasonable judge could have reached the same ruling as this judge did in a case where the plaintiff's own experts described tobacco addiction in terms that were specialized, technical, and clinical. If there are no further questions, I'm happy to yield my time.
Thank you, counsel.
Thank you.
Thank you. A couple things. Let me go back. Two things about special. First and foremost, what the court said as concerning what the courts are supposed to do with respect to this issue of harmfulness and the like. It says, as the appellate court evaluates whether the beneficiary of the error has satisfied its burden, the court's obligation is to focus on the effect of the error on the trier of fact and avoid engaging in an analysis that looks only to the result in order to determine harmless error. And then with respect to excluded evidence, the court says, could the exclusion of the evidence that should have been admitted have contributed to the verdict? Unless the beneficiary of the error proves that there is no reasonable possibility that the error contributed to the verdict, the error is harmful.
Do you think that case, in essence, overrules the 2-issue rule?
That was my next point, yes. I'm not sure that...
You could never meet that test in a 2-issue rule context,
never.
right?
Right. So I was thinking about this as I was getting prepared for it, but I don't know really why I didn't think about it more enough when I was preparing the reply brief. But as I was preparing for this oral argument, it came to my thought that I'm not sure the 2-issue rule even survives this decision anymore because the two-issue rule puts the burden back on the person who is affected by the error to show why it was harmful, whereas this puts the burden on the beneficiary of the error to show why it was not. And it's conclusively presumed that it's harmful if they can't.
Assume the two-issue rule still exists, that it's not overruled by this case. Isn't the philosophy behind the two-issue rule equally applicable in this case, which is, for whatever reason, you agreed to a verdict form that had two prongs of it, and we can't tell which of the two prongs the jury made the decision?
I don't think so, no differently than if it was a medical malpractice case. You know, it's funny, he said, well, and the jury was asked to determine whether the doctor deviated from the standard of care and whether that deviation was a legal cause of the plaintiff's damages. That doesn't invoke two-issue rule. Likewise, addiction doesn't. If you look at the question that the Douglas jury was asked, the question that they asked on the verdict form was whether or not Mr. or Mrs. Douglas was a member of the Engel class. That's the question that was approved by the Florida Supreme Court when they affirmed the Douglas verdict. In closing on this, I want to point out a couple of things. Nowhere in their...
You're out of time, so make it quick.
Yes, Your Honor. Nowhere in their briefs, nor today, have they addressed the Alexander case, which clearly stands for the proposition that the smoker is allowed to articulate his or her reasons for continuing to smoke. They don't even address it, okay? When there's 4 decisions specifically addressing the issue of whether lay testimony is inadmissible, and all of those cases have said, no, that evidence is not inadmissible. Most respectfully, we would suggest that Judge Egan should have been compelled to follow those cases, admit the evidence, and allow the jury to hear all of it. We don't believe they've satisfied their burden under special, and we would respectfully ask the court to reverse this judgment with directions on remand to allow us to have a new trial, allow us to have this evidence admitted, along with the other evidence that was excluded that we've complained about. Thank you.
Thank you, counsel.